All right, so I guess I can formally kick off the hearing. As our executive director just noted, he is in McKeesport, PA, where there's an opportunity for anyone to offer testimony if they'd like. And Mark, just correct me if I'm wrong, but nobody's shown up there or expressed an interest in testifying personally there where you are. Is that right?
That's correct.
All right. I guess just for the record, maybe we should go through briefly that I am present, Todd Stevens, the chair. Our vice chair, Judge Bernstein, is also present, as is DA Sunday. I think that's all the commission members we have present at the hearing. Is that right?
I believe that's correct.
Okay. All right, and we don't have anyone scheduled to offer any testimony either via Zoom or through any other method. Is that right?
That's correct. We had a number of people are signed up and are viewing, and they're welcome to add comments at the end. And but no one has signed up to testify during this hearing.
All right. So obviously the word got out that we were having the hearing, and I do know, some of the folks who are in the audience are parts of organizations that are scheduled to testify at later hearings.
That's correct.
So that makes a lot of sense. All right. Do any other, while we're here, do any of the other commission members have anything they want to offer or add or say while we're here? All right.
Mr. Chairman, if at some point I could give a brief overview for those that are viewing this or going to testify in the future, and also some comments that we've received in writing that I could at least put on the record so that you have a sense of it for future hearings.
Now seems like a good time for that.
All right, thanks. As you know, today's hearing is to cover two proposals that the Commission approved during our June Commission meeting. The first proposal deals with Amendment 6 to the 7th edition of the Sentencing Guidelines, and the second proposal relates to to Amendment 1 to the Resentencing Guidelines. Regarding the Amendment 6 to the Sentencing Guidelines, a number of details there, a number of changes, but at a very high level, the amendments are in response to the enactment of JRI 2, the Justice Reinvestment Initiative, second round, and specifically Act 115 of 2019. That included the repeal of county intermediate punishment and state intermediate punishment, and the replacement of CIP with the incorporation of restrictive conditions as conditions of probation. The Commission was also authorized or mandated by Act 115 to create probation guidelines. And so the proposals include both the development of probation guidelines as well as the incorporation of probation with restrictive conditions, also known as county intermediate punishment programs, into the sentencing guidelines. Specifically to the probation guidelines, there are two aspects to those guidelines. The first aspect focuses on sentences at level 2 of the guidelines, where the court has recommendations that include both probation and short periods of confinement. And the Commission's recommendation is that when the range recommended is RS to 6 or less, the recommendation for the duration of probation is 1 year. And if the range of the guidelines is greater than RS to 6, so RS to greater than 6 or less than 12 months, then the recommendation in those situations is probation for a period of 2 years. And that takes into account that many of those offenses in the lower tier are misdemeanor 3 offenses where the statutory max is limited to 12 months, and many of those at the higher tier are misdemeanor 2 offenses. And so although there are some variances to that, that really just sort of locks in what's already available in statute. I'll just note for the record, I see Judge Tucker has joined us, so I wanted to make sure that was reflected as another member of the Commission on the call. And I see Representative Joanna McClinton is also joining us, so she is also present for the hearing. The second aspect of the probation guidelines deal with the aggregate sentence during a sentencing hearing. And the recommendation is that in those cases where probation is imposed without restrictive conditions, the duration of probation should be limited to 5 years. And in those situations where probation is ordered with restrictive conditions, the recommended maximum term of probation for a sentencing hearing is 10 years. So those are the key issues in the sort of the standard parts of the guidelines for Amendment 6. The other provision that is pretty involved, and I won't go into it, but it's available on our website, are changes to the enhancements. And there are 2 changes to the enhancements that take into account modifications of existing enhancements. One deals with the youth in school or school and youth enhancement that deals with drug delivery to minors or in a school zone. And the commission, in effect, right-sized or flipped the recommendations that the lower enhancement would apply to school zones, the middle enhancement would apply to delivering drugs to minors, and the top enhancement would be delivering drugs to minors in a school zone. So just a flipping of some of the categories from what was previously in the guidelines. The commission also has a domestic violence enhancement, and one of the provisions is that if a minor is within sight or sound of domestic violence, that the commission recommends that the court consider ordering the defendant to pay for the treatment related to the minor. And this proposed amendment to the guidelines would also include the cost of assessments in those fees that would be ordered to the defendant. And then the third enhancement is a new enhancement dealing with sexual extortion, and that was added to the guidelines. As some additional factors within the guidelines, the commission has asked for comments on 3 potential enhancements that are pending before the General Assembly. One for the offense of causing or aiding suicide, Section 2505B of Title 18. The second is for sexual abuse of children, Section 6312 of Title 18. And the third is aggravated assault by vehicle and homicide by vehicle, Sections 3732 and 3732.1 of Title 75. So the commission is seeking comments on those matters that are pending before the General Assembly, since they all include, if enacted, include mandates for the commission to create enhancements. Since we've published the guidelines, we have received some comments from the public regarding those proposals. And I'll just make a note of one of these because it's an issue that commission members raised during our discussions in June, and it's been echoed in a comment we received from attorney Stuart Suss, and that has to do with the use of the word shall. The guidelines include, especially related to probation guidelines, the word shall, and during the commission meeting, members raised concerns about that because it sounds like a mandatory, and we're talking about guidelines which are advisory. And the justification was that within the context of the guidelines, these are the rules of the road, although courts, once they understand the guidelines, can then depart from the guidelines. But the issue was raised again, so staff has committed to reviewing the language and bringing it back to the commission during the September meeting in case there's any kind of recommendations for changes to how we draft that language to try to provide an alternative to shall. And it probably gets more to the idea of reinforcing that these are recommendations, that these are not mandatory provisions. So those are the key takeaways related to Amendment 6 of the sentencing guidelines. The other matter before the commission are resentencing guidelines, Amendment 1. And the substance of Amendment 1 is relatively minor, but it has to do with a statutory provision that says at the time of resentencing, the court should give due consideration to any time the person's already spent under service of that original order. And so there were concerns that because we are recommending the court goes back to the original guidelines to consider when resentencing, that it would be helpful to remind the court of that statutory provision. And so the commission incorporated that into a revised definition for resentencing guidelines. The only other matter regarding resentencing guidelines, I think you'll hear about on Thursday during the public hearing, and it has to do with some of the research we've been doing with vital strategies related to public health issues related to revocations of probation and resentencing. And so I just wanted to point that out, that in consideration of resentencing guidelines, there is we've received comments, and I think you'll hear testimony on Thursday about consideration, especially for technical violations, that courts take into account public health, drug and alcohol, mental health issues, things like that, when thinking about resentencing those offenders. So more about that later in the week. That concludes the recapping of the proposals. Thanks.
All right. Does that prompt any comments or questions from any of the commission members while we're all here? All right. All right. Mark, is there anything else we need to cover while we're all here?
No, but I'll ask Ryan or Christy to check if there's any hands raised or any individuals from the audience that have changed their mind or wish to make comments or give testimony.
It does not appear that anybody is so moved at this time, Mark.
I have a question for Ryan on an unrelated matter. So, I mean, regarding sentencing, but not regarding the issues before the public. So, yeah, it has to do with the SGS web.
Sure. I'll hang around after, Judge.
Okay.
All right. Well, if there's no other comments or questions and nobody else seeking to be recognized for the purposes of the public hearing, we can adjourn the public hearing and get on with our day. And I guess we'll see everybody in 2 days.
Sounds great.
All right.
All right.
Thanks, everybody.
Thank you
Safe
all.
travels.
Thank
Thank
you.
you.
Questions?